Good morning, everybody. Good morning. I got a chance to talk with most of you this morning before we got started, and it seems like we have a nice variety of businesses here today. We've got some that are in the creative fields, we have some in manufacturing, and some other different types of sales and service organizations as well. So thank you for coming. I tend to keep things a little bit casual, so feel free to interrupt me with questions at any time. As Dion mentioned, I started my own firm a year and a half ago, and that's really when I started taking an interest in social media for business purposes. It was one of the things that I thought I could do to market my business, help get my name out as much as possible, and of course I thought it was cost effective as a new business with concerns about cash flow, which if you have a newer business, I'm sure you can relate to as well. So I started really getting involved with social media at that time, and I realized that a lot of business owners were trying to use social media to market their companies, but there wasn't really anyone out there giving advice on the legal issues that they should be aware of and the pitfalls that they should try to avoid. So that's what we're going to try to cover today. As I said, feel free to interrupt with questions. Social media has just exploded, as I'm sure you're aware. This is just a small sampling of some of the resources that are available if you want to use social media. I have to say I'm not even using all of these, but these are some of the more common ones that I've heard of. And we're really seeing social media being used in a lot of different arenas. We have an election coming up. You're seeing that a lot of political campaigns are using social media to keep in touch with their voters. Celebrities, of course, are really involved with social media. If you remember a year or two ago, there was a big issue of Ashton Kutcher was racing CNN to see who could get the first 1 million followers, and Ashton Kutcher won. So celebrities are very heavily involved in social media. The Dalai Lama is an example of a religious leader who uses social media. I'm actually convinced that it's not him who's tweeting. I'm pretty sure he has someone in his office who's handling that for him. We're also seeing it in sports quite a bit. There have been several issues with either players or coaches being fined or suspended for tweeting during games, or sometimes from the locker room if they've been thrown out of a game. So we're seeing a lot of professional sports rules. We have the London Olympics coming up, and there have been regulations put in place to protect the athletes. I don't personally understand how logical those rules are, because, for example, athletes are allowed to tweet during the Olympic Games, but volunteers and other workers at the Olympics are not allowed. So I think it's an issue of player and athlete safety. They feel that athletes can undertake their own safety and tweet as much as they want, but they want the workers to protect the athletes as much as possible. And the last thing I wanted to talk about is a relatively new program. KLM Airlines is rolling out a meet and seat program where you can use either Facebook or LinkedIn, and you can upload your profile to the meet and seat website, and then you can look and see who you want to try and sit by. Because there are definitely people who use their flights to try to network and meet people for business purposes. So right now it's just a tentative program. They've rolled it out on 2 international flights only, but if it's successful, they'll be rolling it out to all of their flights. We're also seeing social media starting to come into the courtroom a little bit. One of the biggest ways that we see it is where it can be used as evidence. And so attorneys are going to Facebook profiles, other social media accounts as a way to impeach witnesses or to find evidence of an admission of guilt. So people who are involved in court cases really need to be careful what they're saying on their Facebook page or on their Twitter account, because if they admit that they rear-ended someone in a car accident, their attorney or the opposing party's attorney can use that as an admission of guilt. There have also been cases where social media accounts have been used as a basis to modify alimony. For example, there was a case from Pennsylvania where a former husband was able to get his alimony payments reduced because his former spouse was tweeting and posting on Facebook about this new young man that she was living with. So the court determined that she didn't need alimony if she was living with another man. It also can be used to determine bias of jurors, which can be important in a lot of civil and criminal cases. And the last thing that we're seeing, at least in other countries, is that Facebook has been used to serve a summons to appear in court. I do think it's going to be a while before we see that here in the United States, but it could be coming somewhere down the road. the point that you should take away from this seminar today is that anything that you put out onto social media can be used as evidence. And that's why it's important to have some processes in place and some procedures for monitoring what your employees are doing or what you are doing yourselves.
Erin, could I ask you something?
Mm-hmm.
In a case where this is used in a court of law, does receiving a tweet count as having read a tweet?
No. When we're seeing it in court, it's always been used as the person, it's been used as evidence against the person who was made the statement.
Okay, as opposed to I received it.
Right.
Okay.
And obviously if you've responded to something, then it's obvious that you've received something. But so far the cases I've seen have all been about what you've said and not what you've heard or seen. So unfortunately, the law has not really kept up with social media because it's growing and changing so quickly that the law is lagging behind. And for example, the Bar Association has not issued any guidelines on what I as an attorney can and cannot do on social media. So I'm going to talk a little bit about some of the cases that we have seen, but the rest of our presentation will be kind of an application of other existing laws to the social media arena. We're going to cover 4 main topics today. Those include marketing, protecting your brand on social media, how you can screen potential employees, and things you can do to minimize your liability for employee posts on social media accounts. We'll get started with marketing. There are a couple key legal issues to be aware of, and those include false advertising, defamation, and violations of right to privacy. So false advertising can include a lot of different things, and those range from the blaringly obvious to some really minor things that maybe people haven't thought about. And a lot of you may be thinking that, well, I have a small business with a local website and I'm just rolling out my blog. Why does the FTC care about what I'm doing? Right now, I've been hearing some rumors that the FTC is going to start monitoring companies and their social media accounts. Right now, they've been starting with larger companies, of course, but as social media becomes more popular, I don't believe that any company is really going to be safe from review. The issue with false advertising is that, of course, consumers place a lot of emphasis on recommendations, endorsements, things like that that they receive from people they respect. Sometimes those endorsements will come from people they know through business, but a lot of them come from things they see on TV or an endorsement or a review written online. And so that's why it's important for all of you who have social media accounts or even just testimonials on your websites that false advertising rules do apply. So this is one example of false advertising and how it can be a problem. There have been a lot of stories lately about the photoshopping controversy. Are magazines and different beauty product companies and things like that, are they photoshopping models too much? And this is a really, it's a case that falls on the far end of the spectrum. Probably a lot of you do not have actresses who are serving in your models, or serving as models in your campaigns, but this is an example of a L'Oreal ad from the United Kingdom. This ad was banned. It shows actress Rachel Weisz in her photoshopped form, and then this is a real picture from one of her red carpet events. And as you can see, she's been photoshopped to make her skin look smoother than in her original picture. And the issue here is that she was banned, or the ad ended up being banned in Great Britain because it was deemed that the photoshopping was so extreme that it didn't accurately represent the effects of the product. So the concern is that consumers are going to look at this picture and say, wow, that product is amazing. I want to go out and buy that wrinkle cream because look at what it did for Rachel Weisz. But if it's really been caused more by photoshopping than by the product itself, you're really misleading your customers. So if you are using photoshopping at all to modify any of the pictures you're using in your advertisements, make sure that you're not going to an extreme that could be misleading to your customers. In a related issue, we have situations where people are emphasizing atypical results. And one of the most common examples of this would be a weight loss program or some herbal diet supplement that you can take. But all that you hear about are the extreme cases where someone lost 6 pounds a week or 50 pounds in a month or something like that. And what you need to do in a case when you are highlighting an atypical result is you need to designate that in writing. You know, you've seen the small print on the advertisements and the commercials on TV. But if you yourself are only featuring testimonials on your websites or on your social media accounts that are really those extreme successes, I would recommend kind of tempering those with some smaller levels of success, and even, like I said, giving a notice on the more extreme cases that designates that those are a little bit more atypical, just so you're not misleading customers into thinking that they can all expect those really extreme success stories. You also need to be concerned about third-party reviews on your website. If you, like I said, just kind of keep a reasonable mix of the really extreme successes and some of the more moderate success stories. Sometimes that will mean taking down reviews from third parties that have been posted. I'm a Jeopardy fan, love Alex Trebek. This obviously is an older commercial because of the graininess, but he has long been a promoter of Colonial Penn life insurance. So this is a screen capture from one of his commercials on TV, and you can see here that he's designated as a compensated endorser. We all don't have Alex Trebek promoting our businesses, but the tip that you need to take away from this is that if you are paying anyone to make an endorsement on your behalf or to recommend your company, if you're receiving anything in return, whether it's a cash payment, free product, discounted services, anything like that, you need to indicate wherever they are making their testimonial or promoting your product that they have been compensated for making that endorsement. A situation that I tend to see more often is the related endorser. There are some companies who have actually hired people to go and make reviews, not on their own sites, but on third-party review websites. For example, hotels on Travelocity or hotels.com. Sometimes there might be a situation where a hotel has an employee that once a week or once a month, something like that, is supposed to go and post a positive review to make sure that they are getting regular reviews, but also to make sure that they're getting a high number of positive reviews if they're having an issue with some lower reviews coming in. So anytime that you have someone who is related to your company, whether it be an employee or an owner, something like that, you should indicate that you are or that person is related to the company. So for example, instead of saying, I stayed at this hotel in May and it was fabulous, you should say, well, I work here and the staff works very hard to keep the rooms clean, something like that. So always indicate if you have someone who's either related in any way or who is receiving compensation. Yes?
And so if you have a website and you're showing some sort of endorsement, how do you need to indicate that they are being paid or a paid consultant paid to be an endorser?
If they are being paid, I would just say, you can do it in small print, but don't hide it obviously at the bottom in really tiny print that people aren't going to be able to read. But either when a lot of times it might be a quotation or something like that, and you'll indicate their name. After you state their name, you can say compensated endorser. The Alex Trebek example was a good example where it said Alex Trebek, compensated endorser. So just translate that into your website text.
Okay.
Erin?
Yes.
Just yesterday I heard on public radio that there is some sort of a scam going on. I use that word. I don't know if it's the correct one. Where people are being compensated to like people on Facebook, or where a water park in Utah was having, buying 1,000 likes per week, and it turned out the people who were liking the water park were in Cairo, Egypt, and Indonesia. So do you see that as just the coming trend, and how legally do you think that can be handled?
Well, unfortunately, it is a newer issue, and I haven't heard of any actual rulings or opinions from a court on whether that's allowable or not. I would say, though, that it is an example where you're kind of buying support for your company. And in a situation where you're buying likes, a like is not as strongly convincing for a consumer as an actual testimonial would be, so it's not as big of an issue. But I still would say that there are other ways that you can get likes on your website that are clearly not going to run afoul of the law. You can run promotions, you know, say that you're going to run a promotion until you get 300 likes on your Facebook page, and once you hit 300, you're going to give away something for your company. That's a way to drive people to like your website who actually have, or like your Facebook page who have actually visited it, instead of people in Cairo and Indonesia who might not speak English, they don't even know what they're liking. So that's one way to try to stay out of trouble on that. Yeah.
I mean, related to that, I know a lot of companies are trying to figure out who are the biggest influencers out there in social media, and then they target them and either give them discounted, you know, products or services or whatever, just to get their, you know, their endorsement. Are you saying that if that happens, that the company should say that this person's a paid endorser on their blog or on their Facebook page or something?
Well, that's also, of course, a little bit of a gray area. There was a situation a couple years ago where there were some moms who were blogging. They had some parenting and mommy blogging websites where it came to light that they were receiving free product from Johnson & Johnson. And, of course, they were talking a lot about Johnson & Johnson products on their blog. I don't think they actually got in trouble legally for doing that, but their readers were very upset about it. So that's one of the things to keep in mind with social media, is that honesty and openness is an advantage on social media. And so it doesn't hurt to say on your blog that, you know, I did receive some free product from Johnson & Johnson. I've reviewed it. This is what I think about the product. And then people know that, you know, they did receive something in exchange, but, you know, you're giving an honest assessment of what you thought of the product. So is that something you can translate into your business?
Not really, but I'm just curious, you know, how, like in that case, would Johnson & Johnson need to disclose
No.
that they gave mommies, these mommy bloggers, free product?
Well, what you run into is an issue of control. Johnson & Johnson doesn't have the authority to say on the mommy blogging website that they gave product. It's the people running the website and making the posts that should say, I received free product from Johnson & Johnson. So if you have a situation where you are giving free product to someone in exchange for them, you know, giving a review or something like that, you can make that a condition of giving them the free product, that if they are going to be making reviews or promoting it, you expect them to disclose their relationship with you or received.
Karen, I'm curious, are there any rules about if you are filtering any reviews or anything that's on your website where people are posting, or maybe if you have a company Facebook page, if you're going in and deleting certain reviews, or, you know, you were saying how you might want to have some negatives and some positives, do you need to disclose that you're doing that the company is kind of censoring some of the reviews that are being put on there, so people know that maybe this is just all favorable? Or?
Well, it's something that you can address in the terms and conditions of your website. You can address, that's a good place to address comments that you will not be posting. For example, the spam, the, you know, derogatory or offensive things. So when you're addressing those sorts of comments and stating that you won't be including those on your website, you can also say that you are managing the comments on your website to accurately reflect the comments you've received on your product, or to accurately reflect the results that people have received from using your services. So let me introduce you to John Krasinski. We're going to talk about defamation a little bit now. For any of the sports fans here in the room, you might recognize that he is a sports writer for the Associated Press. And a couple years ago, he was actively tweeting during a Timberwolves game. And there was a call that he found to be questionable. And so he tweeted out on his account to his 7,000 followers that ref must have been paid off to have made that call. And the ref was very upset about it, because obviously in professional sports, the referees have standards and they can be fined as well. And so it was really a question of reputation for the referee. So the referee ended up commencing a lawsuit against John, and the tweet has been taken down, and it ended up being settled out of court. But you do have to be aware of any derogatory or negative things that you put out onto your sites, because if they're not truthful, you can have an issue of someone making a defamation claim against you. The key components of defamation are that you're making a false or derogatory statement, you're publicizing it or publishing it to another person where they can see or hear it. And it is damaging to the reputation of the person or the company. So this really comes into play if maybe you're being really aggressive in your marketing and you might be comparing your products and services to someone else or another company's. I would recommend kind of backing up any sort of negative statements about another company or product. Document those well, whether it's you had a study done, you did an unofficial survey where you got feedback from people comparing your products with someone else's, or just try to keep your marketing in general positive, and then you tend to stay out of trouble regarding defamation claims. I picked a restaurant, and I was driving by Granite City, so I ended up going to Granite City's website, and this is an image from their homepage. And on this homepage, we see a couple, they're having dinner, their food looks amazing, they look really excited and happy to be eating at Granite City. I don't work for Granite City, I haven't given them any legal advice, but I would hope and assume that they have obtained waivers from the people who are appearing in these images. So this is an example of someone's right to privacy. You need to make sure that you have approval from people that you are featuring on your website to use their image and likeness on your website or your blog or your social media accounts. There are a lot of different pieces to a person's right to privacy. First of those is the rights to their likeness. A person has the right to control how and where their image is being used. That's just the basic. They want to control where they're appearing. But then there's also a person has the right to control how they're appearing, and that's a situation where they don't want to appear in a false light. So for example, someone doesn't want to appear in a picture at Granite City with a caption saying that Granite City is their favorite restaurant. They thought the burger there was the best, better cheddar burger they've ever had. Because maybe they don't feel that way. Maybe they just happen to be there that night to support a friend, and they actually hate Granite City's burgers. So you want to make sure that anytime you're captioning a picture, that you're not exaggerating the person's support for your company. And the third example of a person's right to privacy is that they have a right to control any private facts about them. If a person reasonably thinks that they would have a reason to want to keep something private, a company should not disclose that about them. So for example, you might watch news reports that are talking about the obesity epidemic or health issues in the United States. Have you ever noticed that the news reports only show the people from the neck down? And that's because a lot of people don't want to be associated with discussing issues of weight, or for women, age, or maybe it's an issue of they don't want to be disclosed coming out of a rehab clinic or something like that. So if you work in industries that might have some issues of people wanting to keep their relationship to your company private, be aware of these right to privacy. I'm sure you guys have thought about this on your main websites. The thing that I run into a lot is you might be out at an event somewhere and someone is coming around with their camera phone taking pictures of the people that are at the event, and they want to put it on their Facebook page to say, look at all the wonderful professionals who came to our networking event. The person who's taking the photos should be saying, I'm going to post these on Facebook, do you mind if I take your picture? And use it for that purpose. And if someone says no, they shouldn't take the picture and put it on Facebook. So if you have ever been doing any of those photography sorts of things at your events to promote some of the things you're doing, make sure that you are mentioning to people your intended purpose, and don't use their pictures if they don't support it. Yes?
Verbal consent enough?
I prefer to have it in writing, of course, because then you have it documented. But at a bare minimum, get a verbal consent, and then if someone complains afterwards and you don't have anything written in writing, you can just take the pictures down. All right, so tips that we've talked about, just to summarize really quickly. Make sure you disclose your relationships with endorsers and any compensation arrangements you might have. Avoid defamation by keeping your posts related to your own company and keeping them positive. If you do have any sort of negative things you're trying to respond to, I would recommend taking those offline as quickly as possible. And make sure you obtain a release to use photographs. As I said, a signed release is better, but verbal is okay, especially if it's just going to be on one location that you're just using for social media purposes. And just take it down take the pictures down if you have any sort of a problem. For written releases, you can either have a standalone release that you give to people to sign on the spot, or if you want to get authorization from all of your customers, you can include it into a customer service agreement. And this is what I see a lot for photographers. They want to be able to post pictures of all the weddings they're doing or all the babies they're photographing on their blogs, their websites, things like that, as an example of their work. So a lot of times they just include it in their standard contract, and that's part of the deal. If you hire them, you're authorizing them to use your photographs. So some tips for protecting your brand online. All of your companies have trademarks. All of your companies likely have copyright rights to materials on your website, and I want to make sure you're all aware of those. So in general, a trademark is any sort of a slogan, a name, a product name, a tagline, anything that you're doing to build the recognition for your company. Like I said, it can include a lot of different variety of things, but in general, it's just something that people are going to associate with your company and recognize that it comes from your company. The initial rights to a trademark come from using it, and that's where you get your most basic level of protection just by using a trademark. But you do get additional protections if you go through a state or a federal registration process. What you can do on your social media sites and on your website in general is make sure you're including a trademark notice. If you haven't gone through a registration process, you want to include the letters TM for trademarks or SM for service marks, just after the name, or your logo, anything that you want to claim protection to. And that will inform other people who are viewing your websites and your social media accounts that you are claiming trademark rights to it. They shouldn't decide that, gee, that's a really catchy slogan, I'm going to take that and use that for myself. If you do go through a registration process at the federal level, then you're entitled to use the R in a circle that I'm sure you've seen on various products in the market. And that, like I said, that designates the federal registrations, that you're protected by federal law, and that gives you some rights if you have an issue of infringement.
If you do not use either the TM or the little trademark in a circle, if you do not display that, do people have the right to assume that phrase or that word or that mark is not trademarked?
They don't have the right to assume that it's not trademarked, but they can claim a defense that they didn't know you were claiming protection to it. And you can still ask them then to stop using your trademark, but your rights are going to be much less. Basically all you would be able to get would be a court order saying, hey, cut it out. But if you have gone through a registration process and you've forgotten to include the notice, that's really it. But if you have gone through a registration process and you have included the notice, you can get some additional damages like attorney's fees, lost profits. You can order destruction of any products and marketing materials that are infringing on your trademark. So forgetting to use the notice is a pretty big deal if you've gone through the registration process. You also, a lot of you, especially in creative industries, might have copyright issues that you should be aware of. Copyright is a little bit of a broader protection in that it really applies to not just names and slogans and things like that, but all of the creative content that would go on a website or on your blog. So if you have people that are writing posts for your blogs, they're writing individual tweets, they're writing Facebook posts, technically those all have, as creative original content, those are copyrightable and they can have copyright protection to them. So again, I would recommend including a copyright notice on your website. It's a lot harder to use on a Facebook page and a Twitter account, but it's good to, where possible, include a copyright notice. I have an example here on the bottom. The copyright symbol, the year that the post or the work was first published, and then the owner. Obviously, you want to include the owner of the copyright so someone knows who to contact if they want to license use of anything that you've written or created. Examples of copyrightable materials include the obvious ones, movies, books, music, things like that, but it does actually apply to you as business owners because you are creating content that you're putting out on your social media accounts. So don't forget the little things that your employees might be writing for you and putting out on your web pages and your social media posts. And if you're sitting there looking at me thinking, I don't have intellectual property, why do I care about this? Think about a tattoo. I never would have thought of a tattoo as being something that could be a valuable copyright. I would have thought, why even bother with it? But this is a screen capture from the movie Hangover 2 that came out a year ago. And maybe you didn't hear about it at the time, but actually the movie almost was delayed in its release date. The tattoo used in the movie is an exact copy of the tattoo on Mike Tyson's face, and he makes a cameo in the movie. But the issue is that the tattoo artist who put this on Mike Tyson's face claimed that the studio who created the movie didn't have permission to use the tattoo in the movie. And they claimed that, the artist claimed that it was a key component of the plot line, that the movie would have been much less enjoyable and would have made much less money for the studio if they hadn't been able to use the tattoo. This, again, also ended up being settled out of court. Well, the court ruled that the movie could be released on time, and then after that, the parties settled on a monetary settlement. But this is an example of, if you think you don't have anything that's copyright protectable, think again, because tattoos are. I'm guessing you all have something in your company that gives it value that should be protected as intellectual property. So tips for how to protect your brand online. Always display appropriate trademark and copyright notices, even if you haven't gone through a registration process. Actually consider whether a registration is going to be right for you or not. There's a lot of people that just kind of assume that they're not going to get any value out of doing that, and that's not always the case. So make sure you're making educated decisions. If you're starting a new company or releasing a new product, I would recommend doing a trademark search to make sure that you're not going to roll out a new product that's going to infringe on the trademark rights of someone else. Because I'd hate to see you start a company or release a new product with a huge marketing campaign only to receive a cease and desist letter shortly thereafter that's going to require you to change it all and invest a whole lot more money. Make sure that you're monitoring and enforcing your rights. It doesn't do a lot of good to include the notices, to go through the registration process if you're not actively managing your intellectual property. So do occasional Google searches. See if someone else is using those key components that give value to your business, the name, the slogan, the logos, things like that. So just be proactive. And finally, if you have employees who are involved at all in your online presence, make sure that you instruct them on the proper things to do. Tell them that they need to include a copyright notice on the bottom of your blog, or tell them that they need to include the trademark notice when they're referencing your company name in any sort of a post.